Chap. 11. Disabilities incurred. There is a general disability to perform legal acts incidental to the unhappy situation of an idiot or lunatic. Their incapacity is obvious, but it is necessary the effects of it in many cases should be considered as they have occurred in the administration of justice. I have endeavored to compress them under the following heads. 1. Attornment. 2. Presentation. 3. Marriage. 4. Copyholds. 5. Testimony. 6. Actions and suits. 7. Wills. 8. Trusteeships. 9. Contracts by deeds, and c. Papeis. 10. Fines and recoveries. Sect. I. Attornment. A man deaf and dumb, and yet having understanding, may atone by signs, but one that is non-compass cannot atone, for he has no understanding, and cannot agree to the grant. Re-entry may nevertheless subject one to distress and action of waste, who of himself could not atone, for if a man, non-compass, be lessee for years rendering rent, and the lessor reject him, and make a faufement, and afterwards the lessee re-enter, his liability must attach, although he was incapable of an attornment, for the re-entry revests all interests and estates. Sect. 2. Presentation. A lunatic cannot present to a church, nor his committee, for where a lunatic is seized of an advowson, the Lord Chancellor, by virtue of the general authority delegated to him, presents to the preferment, whatever be its value, generally, however, giving it to one of the family. This right, says Mr. Woodson, was asserted by Lord Talbot, whose example was followed by his immediate and other successors. As to a clergyman himself becoming lunatic, see ante, par. 17. Sect. 3. Marriage. One of the incapacities established by the English law is want of reason, without a competent share of which, as no other, so neither can the matrimonial contract be valid. It was formerly adjudged that the issue of an idiot was legitimate, and consequently that his marriage was legitimate, a strange determination, since consent is absolutely requisite to matrimony, and neither idiots or lunatics are capable of consenting to anything, and therefore, the civil law judged most sensibly when it made such deprivations of reason, a previous impediment, though not a cause of divorce, if they happened after marriage, and modern resolutions have adhered to the reason of the civil law, by determining, as in Morrison's case, before delegates, that the marriage of a lunatic, not being in a lucid interval, was absolutely void. Formerly, when such a marriage was maintained, if the lunatic died, his wife was entitled to dower, for his situation worked no forfeiture, and the king had only the custody of the inheritance in case of idiocy, and a power of providing for him and his family in case of lunacy. But, in both cases, the fee and inheritance being in the lunatic, his wife became dowable. But such a claim is now set at rest. Persons accessory to the contriving the marriage of an idiot or lunatic, who is possessed of property which can alone be presumed to be the inducement to such an union, are acting in contempt, and are liable to an information at the suit of the Crown as the general guardian, and those who are assisting are also liable to be committed to prison, or to give good security, to appear and give evidence of the transaction. Smart v. Taylor. 9 Mod. 98. But such a marriage is not a supersedeas to the commission. It is not barely the having some part in the transaction relative to such a marriage that constitutes a contempt, but it is the being in some manner parties to the contrivance, to show that they are in some degree criminal. Upon a marriage with a female lunatic, the Court of Chancery ordered all deeds and securities relating to her fortune, and all her jewels, to be lodged with one of the masters, in order to secure some provision for her if she should survive the husband, and for children if they should have any, and committed him to the Fleet prison for the contempt. But if the marriage is afterwards held good in the spiritual court, as it may be by being consummated in a lucid interval, and, if upon one inspection it appears that she is restored to her understanding, the husband shall be discharged, and the commission be vacated. It seems to have been a doctrine of the old law, that if the wife be an idiot, the husband would not be entitled to courtesy, so that if lands descended to a feme-covered idiot, who had issue, and the husband have entered before office found, the king, by prerogative, and not the husband, by courtesy, would have been entitled, but it is agreed at present, upon principles of sound sense and reason, that an idiot cannot marry, she being incapable of consent to any contract, As the act after mentioned invalidates the marriage, it of course determines any husband's claim. But this cannot apply to any courtesy in lands of a wife becoming insane after marriage. But as it might be difficult to prove the exact state of the party's mind at the actual celebration of the nuptials, and, considering that such persons are liable to be surprised into unsuitable marriages, which may be of pernicious consequences, and a great misfortune to their families, the legislature interfered in 1742, and enacted that if any person shall be found lunatic by any inquisition by commission, under the Great Seal, or person under affrency, whose person and estate, by virtue of any statute, shall be committed to the care and custody of particular trustees, shall marry before he or she shall be declared of sane mind by the Great Seal, or the major part of such trustees, every such marriage shall be null and void. Notwithstanding this statute, it is held in the ecclesiastical court that dumb persons may contract matrimony by signs, and their marriage is lawful and available to all intents. Now, to be within the prohibition of the statute, they must have been declared lunatic by commission, and whatever may have been the opinions or adjudications of former times, it needs no trouble of demonstration to show that persons born deaf and dumb are necessarily idiots, or come within the least shade of lunacy. It may be that these disabilities are also added to the other privations, but they are rare cases. The skillful exertions of Mr. Braidwood, and of the conductors of the schools for the deaf and dumb, have proved that the human mind, although deprived of its two essential organs of knowledge, elicits as much intelligence as in other cases, when the web which envelopes it is removed with a delicate hand. If a marriage, under the disabilities of insanity, or idiocy, be of no force, it follows that the issue will not be legitimate. But it has been held in the ecclesiastical court, that though it hinders the contract of matrimony it does not avoid that marriage which is already contracted, that is, previous to the lunacy. Section 4. Copyholds. A lunatic cannot become a copyholder, because he cannot render any services, nor depute any other person, and this incapacity saves him from forfeiture, for having no will, no act can operate to that effect. Section V. Testimony. To determine exactly the credibility of a witness, and the force of evidence, is an important point in every good legislation. Every man of common sense, that is, every one whose ideas have some connection with each other, and whose sensations are conformable to those of other men, may be a witness. There are no spontaneous or superfluous sentiments in the heart of man. They are all the result of impressions on the senses. Where those impressions are so violent as to disturb the common organization of the sensorium, and thus disconnect the usual arrangement of thought and memory, and conception, they must necessarily disqualify the testimony of any witness. Therefore it is that all persons who are examined as witnesses, must be fully possessed of their understanding, that is, such an understanding as enables them to retain in memory the events of which they have been witnesses. Hence it is generally laid down, that persons of non-sane memory or wanting understanding, while under the influence of their malady, cannot be admitted as witnesses between other parties, for they do not possess the requisite share of understanding. As to the commission itself, if a witness be produced who is not of competent understanding, the adverse party may accept against him, and the commissioners ought not to examine him. But if the prosecutors of the commission persist in his examination, the other commissioners must certify the matter to the court, and make affidavit of the irregularity. A commissioner may be a witness, but he must be examined before he qualifies himself. And a person deaf and dumb, if of sense to have intelligence conveyed to him, may be a witness, and give his evidence by signs, through the medium of an interpreter. The next of kin of a lunatic, having no interest in the property, even where the lunatic is intestate, and in the most helpless state, a moral and physical impossibility, though the law would not so regard it, that he should never recover, even if he was in articulo mortis, and the bill was filed that instant, to perpetuate his testimony, the plaintiff could not qualify himself as having any interest in the subject of the suit. Lord Dursley v. Fitzhardinge, 1801. Section V. Actions and Suits. There was a time when idiots, mudmen, and such as were deaf and dumb naturally, were disabled to sue, because they wanted reason and understanding. But at this day they all may sue. The suit must be in their own name, but it shall be followed by others. They cannot sue or appear by guardian, prochnomy, or attorney, but always in person. The Statute of Westminster 2. c. 15. Does not extend to idiots. Indeed, if he be a minor he must sue by guardian, and if adult, an attorney has been allowed. The lunatic ought generally to be party to a suit, but this was overruled in a bill filed for relief against a debt assigned by the lunatic without consideration, for this would have been to stultify himself. He may be party to a suit to enforce an agreement, entered into before the lunacy, for the above objection does not rise. It is as needful to make the lunatic party as an infant, where the suit is for his own benefit, but in case of an idiot, it is otherwise, for the former may recover, and is then entitled to have his estate at his own disposal. The distinction is, that where he may be led to stultify himself, there he is not to be a party. In other cases he may be a party. If a person who is in the condition of a lunatic or idiot, though not found so by inquisition, is made a defendant, the Court of Chancery, upon proper information of his incapacity, will direct a guardian to be appointed, and if a lunatic be sued, a committee must be assigned to defend the suit. Informations are sometimes exhibited by the Attorney General, on behalf of idiots and lunatics, construing them as under the peculiar protection of the Crown, not only to secure their property, but also against their committees for an account. Lunatics generally sue and answer by their committees. If he be not named a party in the bill or information, it is commonly good cause for demurrer. Bills for these purposes were frequently brought by the Attorney General in the nature of an information, and it was formerly held that the lunatic should not be a party under the old principle of not stultifying himself, but it has since been held, that he must be a party by his committee to a bill, and not an information, because he may recover, which differs from the case of an idiot. These bills are now established in equity, where it is held that this maxim of law is to be understood of acts done by the lunatic in prejudice of others, that he should not be admitted to excuse himself on pretence of lunacy, but not as to acts done by him in prejudice of himself, for this can have no foundation in reason and natural justice. If a lunatic and his committee be defendants, and the latter refuse to put in an answer for him, the plaintiff must proceed against the lunatic, and apply to the Great Seal to appoint a new committee. 2 Dickens, 490, 1772. And though weakness or other imbecility, and drunkenness, may not be sufficient to support a commission of lunacy, yet the courts of law and equity will relieve against acts fraudulently procured in such situations, the cases of which are very numerous, for if a man is deprived of the use of his reason, his act can by no means be a serious and deliberate consent, and without this no contract can be binding by the law of nature. A dumb man has been ordered to answer a bill, and also interrogatories, but one dumb and senseless, so that he cannot instruct his counsel to draw his answer, shall not be put to answer. But where a man was deprived of memory by age, and almost non compos mentis, he was ordered to answer by guardian, the demand in question being of small amount. Otherwise the appointment of a committee would have been the most regular practice. The custody of the land of a copyholder who was a lunatic, was committed by the Lord to J.S. And a trespass was done upon the land, and the court ruled that the action should be in the lunatic's name, for there was no interest gained by this commitment, the committee being only as a bailiff, having no interest but for the profit and benefit of the lunatic, and as his servant, and it is contrary to the nature of his authority to have an action in his own name, for the interest, and the estate, and all the power of suits is remaining in the lunatic, and it was ruled that a lunatic shall have a quare impedit in his own name. Cox v. Dawson. The same rule applies as to ejectments, for he cannot grant leases. At common law, idiots, who, for want of legal discretion, are incapable of appointing an attorney, must appear in person, but where an idiot appeared by her friend, she assigned for error, that being idiot, she had previously appeared and defended the action by attorney. The courts of common law will not discharge a defendant out of custody on filing common bail on affidavits that he had become insane since the arrest, nor if insane at the time of the arrest, nor will they discharge the bail put in above, if he become insane, and a commission of lunacy be found since the commencement of the action. It is a good defense to an action on a deed that defendant was a lunatic at the time. This seems to militate against the rule in Beverley's case, that a man shall not be allowed to stultify himself, But, on the subsequent authority of Smith v. Carr, 1728, when Chief Baron Pengelly admitted it, and on considering Thompson y. Leach, the court suffered it to be given in evidence, upon which the plaintiff was non-suited. But it has since been held, 9 Will. 3, that such bonds are void, because the law has not appointed any act to be done to avoid them, and the only reason why the party cannot plead non est factum is, because the cause of nullity is extrinsic, and does not appear on the face of the deed. The old rule that a man shall not be able to stultify himself by pleading insanity to any act, has been since much controverted, and from its great inconvenience much restrained, and such a plea was advised in Smith v. Carr, and Thompson v. Leach. These were cases at common law, although the principle on which courts of equity in general relieve, appear to entitle the lunatic to relief. There are no cases in which the plea of non-compos by himself before inquisition has been allowed. On the contrary, in Bonner v. Thwaites, it is said that the Chancery will not retain a bill to examine the point of law. A new trial was granted by the Court of Chancery, where that court had directed an issue, and that the jury should endorse the post to at what time the lunatic became so, and they found that the person was not insane at all, although the chief evidence was of lucid intervals, and all agreed that she was habitually insane, and on the second trial a verdict was found accordingly. In a suit in the ecclesiastical court, by the administrator for a legacy, if the defendant plead a release from the deceased legatee, and the administrator would avoid it by an allegation of lunacy or idiocy, that fact must be tried there, and no prohibition will lie, because that court has a jurisdiction of the original matter, according to the rule non est consnem rationi, quod cognitio accessoriae incuria Christianitatis impeditur, abi cognitio cors principalis ad forum ecclesiasticum nocita pertinia. In addition to the general jurisdiction of the Court of Exchequer in matters of equity, a special jurisdiction is conferred upon it by several statutes, such as, inter alia, the 29th Geo. 2. c. 31. Enabling lunatics and others to surrender leases, in order to renew the same. The committee applies by petition or motion in a summary way, and upon hearing all parties, an order is made for his surrender, without levying any fine, and to accept for the lunatic a new lease, similar to the former, as the court shall direct. The fine advanced by the committee for the new lease, and all incidental charges, are to be paid out of the estate, and are deemed a charge upon the leasehold estate, together with interest, as the court shall direct. The renewed leases are liable to all the same uses and trusts, to which the former leases were invested. Idiots and lunatics are incapable by themselves of instituting suits in the exchequer, but they appear in their proper names, and putting their answers, and defend by their committees, who are appointed guardians for that purpose as a matter of course. And if it happens that an idiot or lunatic has no committee, or the committee has an interest opposite to that of the person whose property is entrusted to his care, an order may be obtained for appointing another person as guardian, for the purpose of defending the suit. So if a person in the condition of an idiot or lunatic, though not found such by inquisition, is made a defendant, the court, upon proper information of his incapacity, will direct a guardian to be appointed. If a bill is brought against a lunatic, stating him to be such, it is a motion of course to apply for a commission to assign him a guardian, and to take his answer by such guardian. But if the bill does not state the defendant to be a lunatic, in that case an affidavit, or other evidence will be required, to show the defendant's lunacy, before he can be permitted to answer by guardian. The like practice applies with respect to idiots, and to those persons who by age or infirmity are reduced to a second infancy. His answer may be referred for scandal, but it being upon the oath of a guardian, he, and not the lunatic, is liable to pay the costs, or rather the counsel, who signs such an answer. By the Statute of Limitations, 21 Jac. I. C. 16. Persons becoming non-compos are entitled to bring their actions within as many years after their recovery as others are limited to after the cause of action accrues. Sect. 7. Wills. The law which substitutes a testator in its place, which invests him with the power and character of a real legislature, which grants him the right to change, to discompose, to abrogate, The natural and favorable order of legitimate successions requires at the same time from him both a capacity proportionate to the importance of his ministry, and a plenitude, and if we may so express ourselves, of a superabundance of will, and therefore it renders him capable of all kinds of contracts previously to impressing him with capacity necessary for making a testament. Hence it is that incapacity is of more importance in deciding upon the validity of a testament, than merely in determining upon the force and nature of a contract. Idiots not having understanding are deemed incapable of making any will. This doctrine is to be understood of a mad or lunatic person, during the time of his infancy of mind, but such an one as hath lucid intervals, clear or calm intermissions, may, during the time of such quietness and freedom of mind make his testament, and it will be valid. The will of an idiot, though it were wise, sensible and reasonable, is nevertheless void, as it seems impossible. An old man who is become childish, or so forgetful as not to remember his own name, cannot make a will. So also a drunkard, who, by excessive intoxication, is deprived of the use of reason and understanding, during that time, may not make a will, for the qualification of a valid will is a sound and perfect memory, such a reasonable memory and understanding as shall enable him to dispose of his estate with reason. But if his understanding be only obscured, his memory troubled, and not clean spent, he is not incapacitated. One deaf and dumb by nature, has been deemed incapable of making any will, but the observation suggested under the subject of marriage, relative to this disability, which is now better understood not to be an affection of mind, may, it is presumed, be sufficient to correct this doctrine, and it has been established, that one who is so by accident, may, by writing or signs, make a will. A person that is so by nature, may make signs also, if idiocy or lunacy be not added to his infirmity. To make a valid will, it is not sufficient that the testator have memory to answer familiar and usual questions, but he ought to have a disposing memory, so as to be able to make a disposition of his estate with understanding and reason, which the law calls sound and perfect memory. And by the civil law these persons are disabled from making wills, because the integrity and perfectness of mind, and not health of body, are requisite qualifications, and these they are admitted to have during lucid intervals. The disqualification of idiocy and lunacy to make any devise, is a common law disability, and what shall be said to be a sane and perfect memory at the time of the devise, is a question to be determined at common law. It is founded on the actual incapacity of the party to do any act relating to the disposition of his property. It is therefore necessary that everyone must be of good and sane memory at the time of disposing of his property. One principal evil meant to be remedied by the framers of the clause in the Stat. of Frauds, 29 Car. 2. C. 3. S. 5. Relative to the attestation of wills, was the secret and private manner in which wills were executed previous thereto, and the frauds consequential thereupon, with a view to check which, the clause introduced a third ceremony to be observed in the making of wills, namely, that the signing of the instrument should be s attested, and c. in the application of this word attested to the act of executing the will. The legislature has been considered, in the construction of it, as having called the attention of the person attesting to three several objects, one of which applies to the testator himself, the other two to the instrument. First, that which relates to the testator, is with regard to his sanity, and attention to which in the witnesses, is a necessary inference, as well from the nature of the transaction, as from the objects of the statute. The name of the instrument necessarily imports, that there must be a capacity of disposing in the deviser at the time of executing thereof, and that is so essential to its validity, that a formal declaration of his sound and disposing mind is become the introductory clause in such instruments. In the construction of this statute, therefore, it has been held that the legislature, when it required the witnesses to attest the signing, must, by implication, have required them to attest the capacity of signing. For it was not merely the abstract act or form of signing that the legislature required as one necessary solemnity to the constitution of a devise, for an idiot or lunatic might put his name to an instrument, and yet be perfectly ignorant of its contents. But the legislature, in the word signing, comprehended another idea, namely, signing an instrument intending it to be a will. Consequently the mental power or capacity of willing was necessary, as well as the corporal power of putting the mark or name, to constitute a signing. The business then, of the persons required by the statute to be present at executing a will, is not barely to attest the corporal act of signing, but to try, judge and determine, whether the testator is compassed to sign in equity. Therefore, the sanity of the deviser must be proved, which is one reason why a will can never be proved as an exhibit, viva voce in chancery, though a deed may, for there must be liberty to cross-examine to this fact of sanity. From the same consideration it has become the invariable practice of that court, never to establish a will unless all the witnesses attesting are examined, because the heir has a right to a proof of sanity from every one of them, whom the statute has placed about his ancestor. In conformity with this doctrine, it was said by Lord Hardwicke, in the case of Wallace and Hodgson, that it had been determined over and over, that the devisee must show the deviser to have been of sound and disposing mind when a will was to be established as to real estate, proving that it was well executed, according to the statute of frauds and perjuries, was not sufficient. But Lord Hardwicke added, in the last case, that if they could have produced evidence on the part of the plaintiff, of any act having been done under the will relating to the real estate, he would have dispensed with the rule, being a mere matter of formality. And a will was set aside after 40 years' possession under it, upon account of the insanity of the deviser, although in prejudice of a purchaser. The onus probandi of a testator's lunacy lies on the heir who would invalidate the will, and it is sufficient for the party who pleads the insanity of the testator's mind, to prove that he was in that situation at any time previous to the making his will, although he do not prove this condition at the very time of making it. The reason, says Swinburne, is, that it being proved that he was once mad, the law presumes him to continue so, unless the contrary be proved, as it presumes everyone to be honest, until the contrary be proved, and being proved, then he which is evil to be evil still. So every man is presumed to have the use of his reason, until the contrary be proved, which being proved, then he is presumed to continue still void of it, unless he were so, for a short time, and in some peculiar actions, and not continually for a long space, as for a month or more, or unless he fell into some frenzy, upon some incidental cause, which is afterwards removed, or unless it be a long time since he was assailed with the malady, for in these cases he is not presumed to continue in his former furor or frenzy. Yet it is a hard and difficult point to prove a man not to have the use of understanding or reason, and therefore it is not sufficient for a witness to depose that the testator was mad, or beside his wits, unless a sufficient reason can be given to prove this deposition, as that he saw him do such acts, or heard him speak such words, as a person having reason would not have done or spoken. The same memory for making a will is not at all times, when the party can speak yea or no, and hath life in him, nor when he can answer to anything with sense, but he ought to have judgment to discern, or be of perfect memory, otherwise the will is void. Wills manifestly improper, are not on that account merely to be set aside, as of insanity. The giving more to a younger than to an elder son, or any inaccuracy in devising a remainder over, if both sons should die with issue, instead of without issue, were not evidence on which to say that the testator was non-compos. Burr v. Devil. The superior courts deny prohibition to the ecclesiastical court against granting probate of a will, upon a suggestion of non-compos mentis of the testator, for without probate the executor cannot sue for debts, which might thereby be lost, and the will remain unperformed, and the statute of Henry VIII never intended to lessen the jurisdiction of the ecclesiastical court. A bill will not lie to perpetuate the testimony of subscribing witnesses to the will of a person since become a lunatic, and yet living, although it could be no prejudice to the testator, nor would it prevent the will from being revoked, if he should recover, but it was no will until death, and this would be to perfect what was no effectual act. Had it been maintained, he need not be a party, for nothing was prayed against him. In the case of Mr. Greenwood, who had conceived that his brother intended to have poisoned him, this was the leading source of his infirmity. He afterwards pursued his profession, but this idea was uppermost in his mind, and under that impression he made his will, excluding him from the reversion of his fortune. Cord Kenyon, upon proof of insanity, declared the will invalid, abstracted from the justice of the discretion. An executor, who takes not any beneficial interest, is a competent witness to prove the sanity of the testator. Persons of these disabilities seldom make wills from the suggestion of their own minds. They are generally imposed upon by those amongst whom they have the misfortune to be placed, and therefore the conduct of those around them, as well as the imbecility of their own minds, is generally the subject of inquiry in the courts of justice. But the cases which require the greatest attention, which frequently baffle the understanding of the most acute, and for the proof or decision of which, no certain rules can be laid down, are those of wills made by persons, who, though in sound health and full vigor of body, have the misfortune to labor under the mental derangement, which prevents them forming just and accurate notions concerning the conduct of human affairs. Unlike the idiot, who seems deprived of all reasoning faculties, the madman appears to reason, and unless when the predominant idea, which always possesses these unhappy persons, intervenes, he frequently appears to reason right, insomuch that many instances must have occurred to the experience of all who have been in the habit of attending courts of justice, where persons who have been proved to demonstration, to be utterly deprived of reason, have passed to common and casual observers as people of extraordinary talents and abilities. The reasoning of Lord Thurlow in the case of Attorney V. Panther, is very applicable here. See par. 106 et sec. Many questions have been raised upon the execution of a will during a lucid interval, and that being proved, the will has been held valid and effectual, to all intents and purposes, for the conveyance of real and personal estate as if the testator had never been deranged. If the exact date does not appear, so as to fix it during a lucid interval, yet, unless it express an apparent mixture of wisdom and folly, it ought to be accepted for a lawful testament. All proceedings, founded upon a will, which is afterwards disproved for idiocy or lunacy, necessarily fall, and in actions for account, or dita for the defendant in such cases. When a will is carried to the ecclesiastical court to be proved by the executor, and any disability attaches to the testator at the time he signed it, tending to impeach its validity, the practice is for a proctor to enter a caveat, which prevents the probate passing in the common form. He is then required by the executor to show what interest he has in the estate. On his showing this interest, and declaring that he opposes the will, the executor propounds the same, signifying that it will be proved by attesting witnesses, and files an allegation of the factum of the will and of the testator's competence at the time of its execution. He then examines his witnesses, which the opposing party may cross-examine, and assigns the cause for sentence, which passes, unless the opposing party files his allegation of facts, showing the incapacity, upon which he proceeds to examine his witnesses, who may in like manner be cross-examined by the executor. Neither party see the depositions till publication is decreed, after which either party may set the cause down for hearing, and the validity, or invalidity of the will is then pronounced, and the probate decreed or rejected accordingly. If an executor become a lunatic, the ecclesiastical court grant administration, with the will annexed, to such person as the Court of Chancery appoint to be committee during the lunacy. Section 8. Trusteeship, and offices of trust. The natural incapacity of an idiot or lunatic for any office of confidence or trust is obvious, but the inconveniences are manifold where it happens that trustees of lands or mortgages for others become unable, even with the direction of the Cestuique Trust, to execute any conveyance to other persons. This was a subject which called for the provision of the legislature, and to remedy an evil of such great magnitude, it was enacted that such persons, or their committees in their name, by direction of the court, signified by an order made upon the hearing of all parties concerned, on the petition of the persons for whom they were seized in trust, or of the mortgagor, or persons entitled to the moneys secured upon any lands whereof such lunatic was seized by mortgage, or of the persons entitled to the redemption, to convey such lands in such manner as the order shall direct, and such conveyance shall be as valid, as if such lunatic were of sane mind, and had executed the same. And all such lunatic trustees, and mortgagees, or their committees, are compelled to obey such order, by executing such conveyance as trustees of sane memory are compellable to convey, surrender, or assign their trust estates, or mortgages. It has been held that the Court of Chancery has no authority, on petition, to order a trustee, becoming a lunatic, to convey the legal estate. It can only be by bill filed. There may be evidence in the master's office of his being ill, but there is no reason to denominate him a lunatic. It would be taking, upon affidavits, the cognizance of the state of his mind and legal capacity, which, in courts of justice, is to be established by inquest. There may be cases where his execution of a deed cannot be obtained, and in that case the execution by a committee may be sufficient, but this can only be done by taking out a commission first, and then the court will order the lunatic and his curator to join in the conveyance. The heir of a mortgagee became a lunatic, and being resident in Hamburg, was found non-compos by the proper jurisdiction there, and a curator or guardian was appointed there, for managing his affairs. Held, that the court here was bound to take notice of that, and that he was a mortgagee within this act, and that, on payment of the mortgage debt, he should convey to the mortgager. But the court will not go into the question, unless a grant of the custody be shown. It is doubtful whether the words of this statute include all lunatics, as well such as are at large as those of whom custody has been granted by the Great Seal. It may not be great presumption to say, that if this doubt had not been started, the language of the statute would have appeared sufficiently general. It seems also to be doubted whether it extends to such of whom a curator has been appointed abroad. If a trustee be of unsound mind, though no commission hath issued to find him so, and under an impression of weakness he refuse to transfer stock, under 36 Geo. 3. C. 90. The court will order the transfer. Sims v. Naylor, 1798. This act was made to procure transfer of stock, and payment of dividends of trustees, absent or becoming bankrupt, or when they cannot all be found, and where the stock stands in the name of any lunatic or committee, who might be absent beyond sea, or die intestate, and it become uncertain whether they be living or dead. The Great Seal may order the transfer by the Accountant General, or Secretary of the Bank of England, to any new committee, or otherwise, and to pay the dividends as the order shall direct, and the bank is indemnified for so doing. A lunatic resident abroad, under judicial proceedings there, is not held to be within the statute. Under this head it may be observed, that an idiot or lunatic cannot be an arbitrator, for he has not judgment to make any award. Nor can he be an attorney or solicitor, for he has not skill to conduct the affairs of others, having none to conduct his own. Neither can he be a signer, but it was held that he may be a steward of copyhold estates, and all his acts, ex officio, are held good. In this case there seems to be a wise reasoning in favour of others, for if a lord should himself be so unwise as to appoint a lunatic to be his steward, it would be a very unfair consequence that all the admissions and surrenders, powers, attornments, relinquishments of dower, and taken before him, should be invalid, and therefore involve whole families in confusion, and it is upon the same principle, that if a judge, the highest office of trust under the crown, should become lunatic, all legal acts done before him, would be maintained. Sect 9. Contracts, by deed, and the faith of every contract rests upon the capacity of the contracting parties. This is a step beyond their fidelity to each other. It is of the essence of the contract not so much that it is valid, as that the parties were in a sufficient capability to bind themselves. For, every alienation of a man's right, all contracts between man and man, all leagues between princes, and ought to be done with sound judgment. Therefore the acts of the will, that are expressed by overt signs, are to be understood as acts of a mind endued with reason, of which a man distracted is wholly deprived, and therefore incapable of performing any profitable things. All promises and contracts are built upon this principle, and so also is the case of oaths, which should never be used but with great deliberation. One criterion of a valid contract is, that both the contracting parties can have redress against each other, if either party are by incapacity at the time out of the reach of full remedy. It is of natural justice that their contract should be void. A mental derangement operating upon particular subjects, scold, with regard to those subjects, be attended with the same effects as a total deprivation of reason, and that, on the other hand, a partial disorder, operating only upon particular subjects, should not, in its legal emphasis, have an influence more extensive than the subjects to which it applies, and that every question should be reduced to the point, whether the act under consideration proceeded from a mind fully capable, in respect of that act, of exercising a free, sound, and discriminating judgment, but in case the infirmity is established to exist, the tendency of it to direct or fetter the operations of the mind, should be in general regarded as sufficient presumptive evidence, without requiring a direct and positive proof of its actual operation. Where the existence of derangement is shown in general, the partiality of its operations in the particular instance should be manifestly and incontestably proved, in order to prevent the application of its general effect. This suggestion is offered, because the distinction must always be made as to contracts by lunatics, whether they were made in a lucid interval. The unfortunate malady which affects the persons who are the objects of our present attention, necessarily works that incapacity in them as to invalidate all their contracts, and to favour the interposition of equity and law in annulling and avoiding acts which, if suffered to remain binding, might confirm their own ruin, and that of their families. This part of our subject is perhaps of the most importance, and has been viewed in various lights by the decisions of the courts, which have distinguished between acts done in payes, and those upon record, as fines, and c. An agreement of the lunatic cannot of course be carried into a specific execution, but the change of the condition of a person entering into an agreement by becoming lunatic, will not alter the right of the parties, which will be the same as before, provided they can come at the remedy. As if a legal estate is vested in trustees, a court of equity will decree a specific performance, and the act of God will not change the right of the parties. But if the legal estate be vested in the lunatic himself, that may prevent the remedy in equity, and leave it at law. Owen v. Davis. Although weakness or other imbecility, and drunkenness, may be sufficient to support a commission of lunacy, yet the courts of law and equity relieve against acts fraudulently procured in such situations, for if a man is deprived of the use of his reason, his act can by no means be a serious and deliberate consent, and without this no contract can be binding by the law of nature, and any conveyance made by a person of weak understanding, though not lunatic, may be set aside. Lord Hardwicke refused to set aside a contract made by a party who was drunk at the time, as there did not appear to have been any unfair advantage taken, and the agreement was reasonable in itself. But in an earlier case, Lord Chief Justice Holt held that a person might show, in opposition to the validity of a bond, that he was made to sign it when he was so drunk that he did not know what he did. They have, however, been deemed capable of purchasing, and although they recover their senses, cannot waive the purchase, and if they then agree to it, their heirs cannot set it aside. If they die during their lunacy or idiocy, then their heirs may avoid their purchase, as the king has the custody of idiots. He may, upon office found, annul it, and after a lunatic is found so by inquisition, his committee may vacate it. If the contract be just, and the consideration bona fide, and part of it paid, the court will order a specific performance of it, and though an agreement be only partly executed, yet if the parties have all acted upon it, this will take it out of the statute of frauds, for it is fraudulent in one party to contract and lead the other on, and then withdraw from his performance. The mutual consent necessary to constitute the validity of any contract, implies capability in the contracting parties, without which, as the basis of the contract, the agreement becomes void, on principles both of law and justice. Every principle of virtue is founded on this capability, for there can be no account where the rational principle is deranged. Every moral obligation, and every rule of public and private duty is also built on this foundation, and where that is not found, the happiness and welfare of society being in danger of interruption, the human, ceasing to be governed by those ties which unite and govern the social compact, falls to the level of the brute, and being equally, or in some cases more fierce, requires more coercion or confinement, and as in this unfortunate state the mutual obligations of every contract and right of expectation of one side, and the knowledge of that expectation on the other, cannot be accomplished, it becomes impossible that an idiot should enter into any valid contract, or any person with him, and that such as have been entered into with lunatics, can only be maintained in lucid intervals, to prevent and relieve, as much as possible, the forlorn situation to which human nature is thus reduced in these afflicting cases. The common law of England, sanctioned by its early Parliament, has vested in the Crown, as a part of its most splendid and dignified ornament, the tender care of those, who, thus born under its allegiance, cannot yield any of the services of subjects, or bring into the common stock any of their personal aid, and as incapable of virtues, can only ask to be forgiven and protected from their vices, and while incapable of industry and activity, to manage and increase their own talent, rely upon the Crown for the custody, the safety, and the comfort, of their persons, and the preservation of their property. Courts of equity will not only sustain contracts completed by a lunatic while sane, but, under circumstances, will enforce performance of such as were entered into before, but were not completed at the time of his lunacy, for the change of the condition of a person entering into an agreement, by becoming lunatic, will not alter the right of the other parties, where the lunacy, alleged at the time of the agreement, was denied, and a sum tendered in the confirmation of the contract. It was, on motion for directions, desired that the receipts might be general, or in pursuance of the order. And the court said, they might give such receipts as the defendant desired. It could not harm the lunatic, being only the committee's acts, nor should it prejudice them on the hearing. A bill was filed by a lunatic and his committee to set aside a settlement which had been obtained from him before the issuing the commission of lunacy, but subsequent to the time when he was found lunatic, and the bill charged several acts of insanity and distraction, previous to the making of the settlement, and issuing the commission, and that the commission was still in force. To this bill the defendant demurred, for it was against a known maxim of law, that any person should be admitted to stultify himself, and see. But the court overruled the demurrer, and said, that the rule was to be understood of acts done by the lunatic to the prejudice of others, that he should not be admitted to excuse himself, on pretence of lunacy, but not as to acts done by him to the prejudice of himself. Besides here, the committee is likewise plaintiff, and the several charges of lunacy are by him in behalf of the lunatic, and it has been always holden that the defendant must answer in that case, and so he was ordered to do here, though the settlement was not unreasonable in itself, being only to limit the estate in question to the defendants the uncles, on failure of issue male of the lunatic, with power for the lunatic to charge the same with considerable portions for his 3 daughters, with a power of revocation rideler v. rideler. G. A lady subject to such a furor or uterinus as to produce temporary derangement, with lucid intervals, was the legatee of stock for her separate use. Her husband received the dividends by a power executed by her. An issue was directed from Chancery, whether the lunatic, when she executed the power, was not found so. A new trial was prayed, and Lord Thurlow said, there is an infinite, nay, almost an insurmountable difficulty in laying down abstract propositions upon a subject, which depends upon such a variety of circumstances as the present must necessarily do. General rules are easily formed, but the application of them creates considerable difficulty in all cases in which the rule is not sufficiently comprehensive to meet each circumstance which may enter into, and materially affect, the particular case. There can be no difficulty in saying, that if a mind be possessed of itself, and that at the period of time such mind acted, that it ought to act efficiently, but this rule goes very little way towards that point which is necessary to the present subject, for though it be true that a mind in possession of itself ought, when acting, to act efficiently, yet it is extremely difficult to lay down, with tolerable precision, the rules by which such state of mind can be tried. The course of procedure, for the purpose of trying the state of any party's mind, allows of rules. If derangement be alleged, it is clearly incumbent on the party alleging it to prove such derangement. If such derangement be proved or admitted to have existed at any particular period, but a lucid interval be alleged to have prevailed at the period particularly referred to, then the burden of proof attaches on the party alleging such lucid interval, who must show sanity and competence at the period when the act was done, and to which the lucid interval refers. And it certainly is of equal importance that the evidence in support of the allegation of a lucid interval, after derangement at any period has been established, should be as strong and as demonstrative of such fact, as where the object of the proof is to establish derangement. The evidence in such case applying to stated intervals, ought to go to the state and habit of the person, and not to the accidental interview of any individual, or to the degree of self-possession in any particular act. For, from an act, with reference to certain circumstances, and which does not of itself mark the restriction of that mind, which is deemed necessary in general to the disposition and management of affairs, it was certainly extremely dangerous to draw a conclusion so general, as that the party who had confessedly labored under a mental derangement was capable of doing acts binding on himself and others. The argument urged, by the Solicitor General, that after the removal of the disease, when the morbid affection no longer obscures or vitiates the judgment, the mind will labor under a languor and debility, which, with reference to its former sound and unaffected state, might render its exertion and decisions very unequal and inferior, carries along with it weight, for I agree that the inferiority of mind would in itself be a degree of evidence to show that the disorder was not rooted out. The convalescent state would incline to look forward to the removal of the disorder, but would not of itself show that the disorder was removed. It might allow of the party doing sound and discreet acts, but it would certainly require such acts to be watched and examined with jealousy. Nothing could be more dangerous than to try the state of the mind by individual acts, in those cases, in which the disorder is, as it is most frequently, insanity quo ad hoc. At the same time, though partial insanity does frequently prevail, it must be watched always with infinite care, and it seems scarcely possible to extract from any particular case of this kind, that which will apply to any other. In Coghlan v. Coghlan, the judges seem to have thought that there was a clear interval, and this was proved by persons in the habit of watching the patient. Such persons can best prove whether the derangement had entirely ceased, or whether there was a perfect interval. By a perfect interval, I do not mean a cooler moment, an abatement of pain or violence, or of a higher state of torture, a mind relieved from excessive pressure, but an interval in which the mind, having thrown off the disease, had recovered its general habit. In Greenwood v. Greenwood, the question turned upon this, whether a mind sound to general purposes, in the doing of a particular act, being influenced by a false imagination, an unreasonable persuasion was not sufficient to avoid such act. A question of so great extent involves serious consideration. The present case, however, is free from all difficulties of that kind, for there is clear and distinct evidence of the party having been, at one period, mentally incompetent. The woman who attended her, was hired to attend, and did attend her, as an insane person. The medical man who attended her, prescribed for her as such. Nor is there any contradiction in the evidence in this case. They who represent her as having talked reasonably, about her property, certainly apprehend that such short effort of her mind made her capable of disposing, and that the disposition to her husband was proper. They did not mean to circumvent a weak mind, but I think they scarcely watched the means with sufficient attention. Their characters are not impeached. It is, however, an agreed point, that she was once undoubtedly insane, but it is said, that this particular disease, furor uterinus, ought to be deemed a bodily disease, but if it were, and the effect of it produced this constant habitual derangement of mind, it comes to the same end. The jury, however, would not act upon this, the evidence does not prove it, and the medicines administered were not applicable to such complaint. The jury were to try this question, with reference to the effect of an instrument, revocable in its nature, and therefore the directions, as to the time, were necessary. Nothing can more circumstantially mark an habitual derangement, than the conduct of the husband with Mr. It is impossible to overlook what was the opinion of the husband. Therefore it comes to the question of a person habitually deranged, and whether there was between the paroxysms of the disorder any clear, decided, lucid interval. I think it would be extremely dangerous to all property to say in such a case. The verdict is clearly wrong in saying, that she was not insane at all, as all the witnesses agree that she was habitually insane, but whether there was a clear lucid interval, is a much nicer question. Upon a new trial, the jury found for the plaintiff, Attorney v. Panther. So likewise it was held, that if one who becomes non compos mentis by accident be decised, and suffer a descent, and afterwards recover his memory and understanding, yet he shall never avoid the descent, and so it is a fortiori of one that hath lucid intervals. If an idiot contract for necessaries in housekeeping, he is bound to pay for them. The right and interest in the profits of an idiot's estate has relation back to the time of the office found, not from his birth, but the office shall relate back to his birth in some respect, viz. to avoid all mean acts done by him, for the king has the custody of an idiot, not in respect of any seigneury, but jury protection is surrigi, because his subject is not able to govern himself, nor the lands and tenements which he has, and his protection begins by the office found, and by statute head 3. c. 9. The king shall take the profits from the time that he is charged with the finding of the idiot and his family necessaries, and that is after the office found. If therefore the king should grant, to one that intrudeth upon the possessions, or takes the person unlawfully, that he would not prevent them, such a grant would be void, for these are acts of justice and offices of a king, which he cannot put off, cessat ignea si non vis judicare, and in this matter he is never supposed by law ill affected, but abused or deceived, for idem presumitur mens regis quisist juris. M. Are devised to charitable uses by a lunatic, in not aided by 43 illas. c. 136. Many that have capacity to take, have no ability to inferf, idiots, mudmen, deaf and dumb, and blind, from their birth. The testaments of these may be avoided. But any one deaf, dumb, and blind, if he hath understanding and sound memory, and express his intention by signs, may inferf, if lands fall by descent to a man that is non-compass, during his incapacity, his heir may enter instead of him, for he cannot plead his insanity, and if he makes a fofement, he cannot enter and reclaim by writ dum non fuit compos mentis, for he cannot be allowed to stultify himself. But his heir at his death may have such writ, and thereby avoid the deed. If an idiot make a fofement in fee, he shall, in pleading, never avoid it, by saying that he was an idiot at the time of his fofement, and so had been from his nativity, but upon an office found for the king shall avoid it for benefit of the idiot. So it is of a non-compos mentis by accident, and of him who enjoys lucid intervals, if an estate be made during his lunacy, for the parties themselves cannot be received to disable themselves, yet a jury may find the truth. But if any of them alien by fine or recovery, this shall not only bind himself but his heirs also. Several opinions were entertained relative to this doctrine of alienation, or other act of a man that is non-compos. 1. That he may avoid his own act by entry or plea. 2. By writ, and not by plea. 3. By writ, or plea, of which opinion was Fitzherbert. 4. And Littleton is of opinion, that neither by writ nor by plea, nor otherwise, he himself shall avoid it, but his heir, in respect his ancestor was non-compos mentis, shall avoid it by entry, plea, or writ, and herewith the greatest authorities of our books agree, and was so resolved in Beverley's case, but this holdeth only in civil cases. Although they cannot stultify themselves, yet all contracts with them after office found, are at the peril of those who deal with such persons, and if the commission be superseded or discharged, the lands revert to the lunatic, but this must be at the suit of the committee. A grant of persons out of their right mind, whom we call non-sane memory, or non-compos mentis, is avoidable. It may be avoided at any time, by entry, action, and c. If they deliver it with their hand, as in a fofement, and themselves make livery, or a gift of goods, and deliver them in person. But if they deliver it not with their hand as a grant of rent, advowson, and c. or a fofement by letter of attorney, and c. it is merely void, and nothing passeth, for the power is void, so as they may have a trial or assize, and remain tenant to the lord, and therefore shall be in ward, notwithstanding any fofement. The mere execution of a deed is absolutely void as against his heir, who may plead the disability, though the lunatic cannot plead it himself. So of a grant made by one that hath no understanding, as if he be born dumb, deaf, and blind, but one dumb, or born dumb and deaf, may make a good grant, for divers may have understanding by their sight only, although they be dumb and deaf. Yet it is said, such grants and surrenders are void ab initio, and the heir may maintain trespass against the grantee for distress for a rent charge, but if the distress had been during the life of the grantor, it could not have been avoided. Livery and say eyes in by the lord of his escheat, for though it might be avoided by the heir, because he was privy in blood, yet it could not be avoided by one who was only privy in estate. In every good fofement there must be a good fofferable to grant, a fofie able to take, and a thing grantable. Therefore, whosoever is disabled by the common law to take, is disabled also to make a testament, gift, grant, or lease, and many also who have capacity to take by such conveyances, have no ability to grant them, as idiots, and see. All grants, gifts, and see, made by deed in pays by those who are nonsen memory, are good against themselves, but voidable by their heirs, executors, or those that have their estate. But if it be by fine, it is good and unavoidable, for that is done of record, and binds themselves and all under them. Of this more hereafter. But a rent charge, granted by a lunatic, may be avoided by the heir, and held to be discharged. A surrender by non-compass is likewise void, but the contingent remainder is not destroyed. The cases of infants and non-compass are parallel in all things, except that the latter cannot stultify himself to avoid his grant. The reason why fofements of infants and non-compass are voidable only proceeds from the solemnity of livery of say eyes in the sight of the country, which takes notice of the notorious alteration of the possession, but contra of a deed, which may be delivered in a private manner. The word demisit in the writdom, and see, means only a few fofement with livery by himself, for fofements and fines were the ancient conveyances, and the only ones used in those days. It is not for defect of right that a non-compass cannot avoid his own fofement, but by reason of his personal incapacity, that no man shall be able to stultify himself. Thompson v. Leach. This is founded on the doctrine laid down by Lord Coke: every deed, fofement, or grant, which any man non-compass mentis makes, is avoidable, and yet shall not be avoided by himself, because it is a maxim in law, that no man of full age shall, in any plea to be pleaded by him, be received by the law to stultify himself, and disable his own person, because, when he recovers his memory, he cannot know what he did when he was non-compass. If the common law had given a writ of non-compass mentis to him who has recovered his memory after alienation, certainly the law would have given him remedy for maintenance of himself, his wife, children, and family, although he recovered not his memory, but continued non-compass mentis. Those who are privies in blood may show the disability of their ancestor, and those in representation the infirmity of their testator or intestate, but those who are only privy in estate, or tenure, cannot do it. Therefore, if doni entail, being non-compass, make a fofement in fee, and die, without issue, the remainder man shall not enter or take advantage of the disability of the donee. The same law holds as to the lord by escheat: if his tenant, being non-compass, makes a fofement in fee, and die without heir, he shall not avoid it. But it is otherwise as to fines, of which hereafter. The avoiding these acts is founded upon the words of the statute: after the death of such idiots, he shall render it to the right heirs, so that such idiots shall not alien, nor their lives shall be disinherited. The method by which the idiot of full age might avoid them was, if he was found idiot by a nativitate, and had aliened his lands by sire faces against the alienee, whereby the lands were seized into the king's hands, and the inheritance reinvested in the idiot, for the king could not render them to his right heirs, nor have possession to his own use, unless by the office and seizure such conveyance be destroyed, and that doth not impugn the maxim of the common law, for in this case the idiot, in no plea that he can plead, shall disable or stultify himself. But all this is found by office by the Inquisition, and verdict of the king's suit, and such office when found shall have relation to a tempore nativitatis to avoid all mesnacts done by the idiot, as fofements, releases, and see. Wherefore after office found all gifts made by him, of his goods or chattels, and all bonds, are utterly void, and if he be sued upon any such bond, or writing, the king, by his writ, so long as the office stands in force, reciting the office, shall send a supersedeas to the justices where the suit is commenced. Although the king cannot have the custody of his copyhold land, that being an estate for life by the common law, and would be of great prejudice to the lord of the manor, yet an alienation thereof by the idiot, after office found, is void. So alienations, and c. before office found, shall be avoided afterwards, because no lackeys shall be accounted in the king, nor any prejudice accrue to the idiot for not suing the office before. But if he die before office found, no office can be found afterwards, and the king cannot be entitled, by the language of the writ. The same principles apply to the case of lunatics, as to alienations, though the king has a different interest, for, as to the idiot, rex habet custodiam, and as to the latter, who may recover, rex providebit, and the principle is, that the king may provide, that he who wants reason, shall not alien his lands, nor waste his goods. Idocy's case. The principles in this case have been the guide to subsequent discussions and determinations, and were recognized in Thompson v. Leach, above mentioned, to render void a deed of surrender, with the distinction already noticed between affouffment and livery, proprius manibus, and that which is void, ab initio, cannot pass any estate to the surrenderee or grantee. It was argued in Thompson v. Leach, that the cases of lunatics and infants go hand in hand, same reason governs both. Their acts are void, because they know not how to govern themselves, and they have a remedial writ to avoid their own intention, which would seem to enlarge the determination in Beverley's case, where the deed was avoided by any other person than himself. It seemed to be assumed, that when a lunatic recovers, he may, like an infant, consider his acts done during his incapacity, and avoid them by showing his indisposition by the visitation of God, as well as pleading duress from man, to avoid compulsory acts. But the court determined, that the grants of infants and persons non-compos are parallel both in law and reason, and there are express authorities that a surrender made by an infant is void. Therefore a surrender made by a person non-compos is likewise void. Some have endeared to distinguish between a deed which gives only authority to do a thing, and such as conveys an interest by the delivery of the deed itself, that the first is void, and the other voidable. But the reason is the same to make them both void. Only where affouffment is made by an infant it is voidable because of the solemnity of the conveyance. If Leach had made affouffment in fee, there had still remained in him such a right, which would have supported the remainder in contingency. The surrender was therefore void, and all persons might take advantage of it, and this decision was affirmed on error in the House of Lords. 1690. The boundary is so narrow and straight between a person who is non-compos, and one who is so weak as to require the caution of a near relation not to sign any writing or paper whatsoever, that it ought not to overturn the equity of an heir at law, because some of his writings go so far as to give such instances as amounted to idiocy or lunacy. There cannot be a greater instance of weakness than such a caution. It is like a nurse warning a child not to go near the water for fear of being drowned. Besides, in the case of Sir J. Lee, it was proved that he was addicted to drinking likewise, which added to his natural debility, that he was almost dark, that one eye was entirely gone, and but a small glimmering of light from the other. They had married him without his so much as knowing he was so, or even without the decency of making a previous proposal to him, which is one of the strongest marks of weakness and liability to imposition ever met with. His repeating scraps of Latin, and reading classic authors, is no proof of sanity, because what a person learns in his youth leaves a lasting impression, and the traces of it are never entirely worn out. The Inquisition had not evidence sufficient to find him lunatic, but the court pronounced him weak upon these circumstances, and a conveyance of his estate, under this unfortunate situation, was deemed the more vulnerable from the grantee having such a power over him, that his name only would quiet him. Its provisions also were objectionable. It restrained him during life, from taking any fine or leasing without reserving the full rent, and the deed was not to be revoked by him, but in the presence of 3 particular persons, or their executors or administrators. Thus he was made to disinherit his heir in favor of persons who were no relations, for whom he had never declared any kindness, nor had they merited any at his hands. A voluntary settlement, and the grantor himself so fettered that he was not able to raise 1 shilling, and as much confined as if it had been a marriage settlement for a valuable consideration. Had there been no such power of revocation, that would have been almost of itself a reason to have set the deed aside. Therefore, for form's sake, one was inserted, but there was no proof that he was acquainted with any of the gentlemen named, or how could he have got them all together, or forced them if they refused. Neither draft nor deed were read to him, but one part was executed, not left with him. How could he remember the revocation? The grantee took it away with him, which amounts to the same as if it had been an absolute conveyance, without any power of revocation at all. Besides, it contained reservations of annuities to the attorney, and c. It is true, if a man be not insane, but only weak, he may do an act which will bind him. There cannot be 2 rules of judging in law and in equity, upon the point of insanity. As to the possibility of his having any intention to disinherit his heir, yet if that intention can be traced up to fraud and imposition, this will fetch back and revest it in his heir, with a saving to his creditors. The deed was ordered to be delivered, and the grantee to pay costs. And it was declared, that an attorney or solicitor cannot excuse himself, by alleging that he only followed instructions, from preparing a fraudulent deed, and therefore he was also directed to pay costs. 1741. The distinction raised by Lord Coke in Whittingham's case T between privies in blood and privies in estate, avoiding the acts of their ancestor non-compos, was denied to be authority in the subsequent case of Thompson v. Leach, where it was said that this distinction was founded upon no manner of authority, but was only his extrajudicial opinion. For there is no reason to be given why privies in estate should not avoid such acts done by their ancestors, as well as privies in blood, because the incapacity of the ancestor goes to both. A contract and purchase, at a lucid interval, 8 years before the Inquisition, when the party was accustomed to buy and sell, was avoided, for the Inquisition took a retrospect of 17 years, but the party had liberty to traverse the Inquisition. But, where it was done before the Inquisition, with the approbation of his only son, the court maintained it. But he must be a party, sticus of an idiot. There is a difference between a will and a deed obtained from a weak man, and upon misrepresentation or fraud. This is not a sufficient reason to set aside such a will in equity, but a deed which is not revocable, as a will, ought to be set aside. 1725. Where a weak man gives a bond, if there be no fraud or breach of trust in obtaining it, equity will not set it aside only for his weakness, if he be compos mentis. Neither will the court measure the size of people's understandings or capacities, there being no such thing as an equitable incapacity where there is a legal capacity. But a breach of a trust is of itself evidence of the greatest fraud, because a man, however careful otherwise, is apt to be off his guard when dealing with one in whom he reposes a confidence, and on such ground the court will relieve against such a bond. Lord Talbot 1734. Thus it appears, in the words of Sir W. Blackstone, that idiots and persons of non-sane memory, and c. are not totally disabled, either to convey or purchase, but sub modo only. For their conveyances and purchases are voidable, but not actually void. The king indeed on behalf of an idiot may avoid his grants or other acts. Hethan proceeds to trace the progress of the opinion of Lord Coke, of a man pleading his own disability. In the time of Edward I. Non-compos was a sufficient plea to avoid a man's own bond, and mentions the writ above stated. But under Edward III, a scruple began to arise whether a man should be permitted to blemish himself by pleading his own insanity, and afterwards a defendant in assize having pleaded a release by the plaintiff since the last continuance, to which the plaintiff replied, on terms as the manner then was, that he was out of his mind when he gave it, the court adjourned the assize, doubting whether, as the plaintiff was sane both then and at the commencement of the suit, he should be permitted to plead an intermediate deprivation of reason, and the question was asked, how he came to remember the release, if out of his senses when he gave it. Under Henry v. This way of reasoning, that a man shall not be allowed to disable himself by pleading his own incapacity, because he cannot know what he did under such a situation, was seriously adopted by the judges in argument, upon a question whether the heir was barred of his just right of entry by the faufement of his insane ancestor, and from these loose authorities, which Fitzherbert does not scruple to reject as being contrary to reason, the maxim that a man shall not stultify himself, hath been handed down as settled law, though later opinions, feeling the inconvenience of the rule, have in many points endeavoured to restrain. And clearly the next heir or other person interested, may, after the death of the idiot or lunatic, take advantage of his incapacity and avoid the grant. And so too, if he purchases under this disability, and does not afterwards, upon recovering his senses, agree to the purchase, his heir may either waive or accept the estate at his option. For these persons are under the protection of the law, which will not suffer them to be imposed upon through the imbecility of their present condition, so that their acts are only binding in case they be afterwards agreed to when such imbecility ceases. Yet the guardians or committees of lunatics, by statute 11 Geo. 3. 20, are empowered to accept of surrenders and to renew in their right, under the directions of the Court of the Chancery, any lease for lives or years, and apply the profits of such renewal for the benefit of such lunatics, their heirs or executors. The want of this power was frequently detrimental to them and their families, and always prejudicial to the persons entitled to the renewal. All fines and premiums thereon are, or so much as shall remain unapplied at the lunatic's death, to be considered as real estate, unless the lunatic shall have been tenant for life only, and in that case as personal. Sect. 3. In like manner where lunatics are interested in or entitled to leases for lives or years, they, or their committees, are empowered under the direction of any court of equity to surrender the same, and take new leases of the same premises, upon the terms of the lease surrendered, or otherwise as the court may direct, and the fine and charges thereon shall be advanced by the committee out of the lunatic's estate, or may be made a charge thereon with interest, and the new lease is to be held upon the same trust as the former. In a bill filed to avoid a lease, on account of lunacy of the lessor deceased, the Attorney General must be a party. The court will not interfere to set aside a contract made fairly and without notice of the purchaser's insanity, especially where the finding upon a traverse was general and not precise as to the day of the contract, as in Furney's case, where nothing in his conduct excited any suspicion of his situation, but on the contrary he appeared intelligent, understanding the business, and conducting himself with singular propriety. The court's interference must depend upon circumstances, and no general rule can be laid down upon it. With regard to purchases that have not been completed, and cases in which it is possible to replace the parties, there is no reason why the court should not interfere to administer its ordinary equity, as it can do that in general in a much better way than a court of law, even supposing that court would consider the mere law of the case in the same way as this court would. But there may be other cases in which the inconvenience would be so great, that this court will leave the party to law. The inconvenience of carrying back the finding is extremely great, if that is to be followed through all the legal consequences, assuming it to be the legal consequence, that every act of the lunatic subsequent to that time is absolutely void. Nothing can be more inconvenient than for this court to give effect to that legal consequence, setting aside every dealing in the course of his trade, giving an account of all he lost, the parties who have dealt with him to take the chance of the transaction, being a losing one and make it good, and the transaction being strictly void, this court acting upon that, and though the parties cannot be replaced, obliging them to refund, though producing the great injustice, that they cannot have that for which the money was paid, or cannot have it in the same manner. That would be most inequitable and unjust, and if this was the principle, must be acted upon in all cases where the lunacy is carried back 10 or 12 years. There is no ground for a court of equity to advance a remedy where it is impossible to exercise the jurisdiction, so as to afford any chance of doing justice to the other party. Where this court does interfere, it endeavors to put the parties in the same situation, that is, where the contract is void, bill dismissed with costs. Grant, master the rolls. 1804. All acts done during a lucid interval are to be considered done by a person perfectly capable of contracting, managing, and disposing of his affairs at that period. This has more frequently occurred upon wills, and they have always been established, it must be the same as to contract, or any disposition of property. If he had made an absolute conveyance, it would have been good. If made in a lucid interval. In the inquiry as to competence, evidence should be found as to his manner of life at the time, the history also of the contract, and the circumstances of the negotiation. Something material to the competence may arise or result from the very mode in which the negotiation was conducted, but it is for a jury to determine what was the degree of efficiency and competence of his mind at the time. And, general lunacy being established, the proof is thrown upon the party alleging a lucid interval, and must establish, beyond a mere cessation of the violent symptoms, a restoration of mind, sufficient to enable the party soundly to judge of the act. This is an inquiry much more fit for examination, viva voce, before a jury, than upon written depositions. If there was a valid and binding contract, the supervening incapacity of one party cannot deprive the other of the benefit. These principles were laid down by Sir W. Grant, Master of the Rolls, who sat for Lord Eden, c. 1804, in a case where a bill was filed for a specific performance of a contract, overreached by a commission of lunacy. The plaintiff not having traversed the Inquisition, an issue was directed, whether the defendant was a lunatic at the execution of it, and if so, whether he had lucid intervals, and whether it was executed during a lucid interval. The difficulties in executing the contract, which was for the sale of an estate vested in the lunatic, viz. that the price was to be fixed by persons to be nominated, not appearing strong enough to preclude the previous inquiry with a view to performance, the plaintiff being willing to take the title. A lunatic, who is lord of a manor, may grant copyhold tenures for any time, according to the custom of his manor, as any other person may do, and the estates made by him are unavoidable. Though this was formerly held, it admits of considerable doubt, from the principles since established, in respect to copyhold estates. Every lord of a manor who is in lawful possession, and has a lawful estate in a manor, may make voluntary grants of copyhold lands, which will bind succeeding lords. If therefore a lord labours under any personal disability, such as idiocy or lunacy, he may, notwithstanding, make copyhold grants, provided they are warranted by the customs of the manor, but he must be in possession at the time of the grant. And his steward may make voluntary grants, notwithstanding the subsequent disability of the lord, who appointed him. The committee cannot grant, having no estate in the manor, but the steward may, according to its customs. Yet the steward may be restrained by order from any such grant, without the privity of the committee, nor until the court have been acquainted with it. This is offered as a caution, as the stewardess grant is good in law. But, notwithstanding all the preceding arguments, great injury frequently happened to persons of unsound minds, and their creditors were delayed in obtaining their demands, for want of sufficient power to apply their property in discharge of their debts and engagements. An act was therefore passed in 1803, directing that the Great Seal being entrusted with the care and commitment of the persons and estates of lunatics in England and Ireland, shall have power to order their freehold and leasehold estates to be sold, or charged and encumbered by way of mortgage or otherwise, as shall be found most expedient for raising such sums as shall be necessary for payment of their debts, and for performing their contracts or engagements, and the costs attending the same, and to direct the committee to execute such conveyance, and procure such admittance, and make such surrender of copyhold lands, as the Great Seal shall direct. 2. Any surplus moneys to be so raised, are to be applied in the same manner, as the estate sold would have been applied before this act. 3. And all powers of granting leases of lands, vested in the lunatic for a limited estate only, may be executed by the committee, under direction of the court. 4. And, in order to encourage buildings, repairs, or improvements, the Great Seal may direct the committee of the estate to make such leases of the freehold, copyhold, or leasehold estates, according to his interest, and the nature of the tenures thereof, for such terms and conditions as the Great Seal shall direct. 5. All such acts done by the committees, by order of the Great Seal, shall be as valid and binding against the lunatic, and all persons claiming under him, as if he were of sound mind, and had done the same. 6. But this act is not to subject any lunatic's estate to debts or demands of creditors, otherwise than as they are now liable to by due course of law, but only to authorize the Great Seal to make such orders, when it shall be deemed for the benefit of the lunatic. Section X. Fines. Notwithstanding the words of the statute of Edward III are general and emphatical, yet if a lunatic aliens by fine or recovery, it shall bind him, for it is held necessary to distinguish between their acts done in payse, and those solemnly acknowledged on record. Neither the lunatic himself nor his heirs, or executors, can vacate any act of his done in a court of record, for it then becomes matter of record which cannot be avoided by a bare averment of non-compass, from the inconvenience which would ensue, and such averment is against the office and dignity of a judge, who ought not to take any cognizance of a fine, or recognizance of such a person, yet when it is once received, it shall never be reversed, because the record and judgment of the court being the highest evidence in the law, the connoisseur is presumed to be at that time capable of contracting, and therefore the credit of it is not to be contested, nor the record avoided by an averment against the truth of it. So it is in the case of a fine by an idiot. No office finding him idiot or nativitate will be sufficient to reverse the fine, for that were to lessen the judgment in courts of record, by trying them by other rules than themselves, and this fine will supersede the king's prerogative. And as fines ought not to be taken from lunatics and idiots, so neither from old doting men who have lost the use of their reason, but if they be weak or infirm through age or sickness, that will be no sufficient cause to refuse them. Idiocy may be judged of by the justices on levying the fine, and if they do admit them, and a fine be levied by such persons, the fine is said to be good and unavoidable. But a purchase undervalued by a lunatic was set aside notwithstanding deeds, fines, and recoveries. The same capacity for a deed is required for a fine, and any person who hath capacity to take by grant, or may be a grantee by deed, may take by fine and be a connoisseur therein. But from the doctrine laid down in the preceding pages, which tends to show the deed on which the fine is founded to be in many cases avoidable, it seems difficult to reconcile the distinction between that and the fine and the consequences which will ensue, for if the fine is not avoidable, a fraudulent grantee will be in by the fine but not by the deed, and if the Inquisition has relation back to the birth of an idiot, or to any number of years of a lunatic, and therefore avoids his acts, it seems that the judge, at the levying of the fine, and the Inquisition of lunacy operate as opposing jurisdictions. If an idiot or lunatic levy a fine to the king and declare the uses of it, he is bound, that being part of the operation of the fine. However tenacious courts of law have been of the authority of their records, and have even maintained a fine, when duly recorded, acknowledged by an idiot, yet in equity relief has been granted to the remainder man against a fine, even against a purchaser. And though in case of fraud it does not set aside a fine, yet considering those who have taken it under such circumstances as trustees, decrees a reconveyance of the estate to the persons prejudiced by the fraud. And though it does not distinctly appear to be the practice in the case of fines levied by idiots and lunatics, yet from the argument in De v. Hungat, such may be inferred to be the rule of proceeding. Although a fine duly levied is as effectual and binding in a court of equity as in a court of law, because it is one of the common assurances of the realm, and was originally instituted for the purpose of securing those who were in possession of lands. Yet if any fraud or undue practice appears to have been used in obtaining a fine, the Court of Chancery has then a power of relieving against it, as much as against any other conveyance. For although it might be extremely improper and inconvenient to admit of an averment in a court of common law, against a fine obtained by fraud, because it would be dangerous to permit the evidence of a record to be questioned in any case whatever, yet as there is a method in which relief may be given in cases of this kind, without contradicting the principles of the common law, it is highly proper that a court of equity should adopt it, and the Lord Chancellor appears to have exercised this jurisdiction as early as the reign of Queen Elizabeth. The Court of Chancery however does not absolutely set aside a fine so obtained, nor does it send the party aggrieved to the Court of Common Pleas to get it reversed, but it considers all those who have taken an estate by such a fine, with notice of the fraud, as trustees for the persons who have been defrauded, and decrees a reconveyance of the lands, on the general ground of laying hold of the ill conscience of the parties, to make them do that which is necessary for restoring matters to their situation. But with respect to any technical error in a fine, or irregularity of the commissioners who have taken the acknowledgment of it, it is a matter only cognizable in the Court of Common Pleas, because a fine, being of the same nature as a judgment, is properly examinable in that court only where it is entered. In what cases laches shall prejudice an idiot, or non compos mentis, some have taken a difference between a bar of his right and a bar of his entry, for in case of bar of his right, his laches shall not prejudice him, but in such special case, if he becomes of unsound memory, he shall show that he was non compos. For if he be deceased and the decisor levy a fine, he is not bound thereby, but may enter, for the stat. De modo levendi fines, 18 ud. I, which is but a declaration of the common law, bars not only all parties and their heirs, but all other persons of full age out of prison and of good memory, and within the 4 seas, on the day it was levied, if they do not put in their claim or enter within a year and a day. So by 4 Hen. 7. c. 24. If a man levies a fine with proclamations, and at the time levied he who had the right was non compos, and afterwards recovers his memory, he ought to pursue his action or make his entry within 5 years after he becomes of sound memory, and in pleading show that he was non compos at the fine levied and all the special matter. But if he never recover his memory, the heir may have his action or enter when he will, for he is accepted out of the body of the act, and is not bound to make any entry or bring any action within any time, but the party himself if he recovers, and in such case the Lord Bias cheat will take advantage of the non-compos of his tenant. For if the tenant is decised and the decisor levies a fine, the decisee being then non-compos, the decisor takes back an estate to himself in fee, and afterwards the decisee dies without heir. The Lord Bias cheat shall take advantage of him against his decisor. So, if a collateral warranty descends upon own non-compos which he might have avoided by entry, but an idiot or non-compos by their laches shall be barred of their entry, and therefore if they are decised and the decisor dies seized, it shall toll their entry, but after their death their heir may enter and take advantage of the infirmity of their ancestor, and his laches, which should prejudice himself, shall not prejudice his heir of his entry. For Littleton saith, no laches can be adjudged by the law in him who has no discretion in such case. The fofment spoken of by Lit. 247, means any other conveyance in payes, but fines or other assurances of record are not implied in this. The note in 2 Vern. 678, seems imperfect, as appears by the Register's Book, of 24th of June, 1711. It was said that although a person be found lunatic with a retrospect of several years, yet if any conveyances are executed by a lunatic after this time, they shall not be set aside as to good uses, and yet they are looked upon as bad, and the effects and a recovery bad where the uses are bad. But there was a fine in that case, and therefore the lunatic was bound, as it must be supposed, when he was examined, with regard to the fine, that he was capable of levying where the ordinary time limited by Street H. 7. and 1. As to fines is gone by, and the person suing, or his ancestor, was within the exception, the lessor of the plaintiff should be prepared with proof of it. The disability should be shown to have existed at the time when the fine was levied or the title accrued, and to have continued till within the time of limitation, for when once the stat has begun to operate, no subsequent disability will prevent its progress. If a tenant entail levy a fine, the issue entail, though a lunatic at the time, is barred forever by it, because he is a privy and out of all the savings of 4H. 7. c. 24. The Act of 23 L. c. 3. does not bar a lunatic or other non-compos mentis of his writ of error, for reversing a fine so that he or his heirs, pursue such writ within 7 years after his incapacity is removed, and if he dies pending the suit, his heir may proceed within 1 year after the 7 years. Idiots, lunatics, and generally all persons of non-sane memory, are incapable of levying fines, and the statute De Modo Levendi Fines expressly directs, that persons of this description shall not be permitted to acknowledge a fine, but still, if the judges or commissioners allow them to levy a fine, it can never afterwards be reversed by any averment that the cognizers laboured under any of those disabilities, because the record and judgment of the court being the highest evidence in the law, the cognizers must be presumed to have been capable of contracting at the time, and therefore no averment can be admitted to the contrary, and it is said that even a declaration of the uses of a fine by an idiot or lunatic will be good. 1 Henry Bushley, a monstrous and deformed cripple and idiot, was taken from his guardian, and carried to a place unknown, where he was kept in secret, until he had acknowledged a fine of his lands before Justice Southcote, to 1 Bottom, and had declared the use of the fine to Bottom and his heirs. Henry Bushley was afterwards found by Inquisition to have been an idiot, a nativitate, and upon an action brought by a person who claimed under Bottom, the idiot was sent out of the Court of Wards upon a man's shoulders, to be shown to the judges of the Court of Common Pleas. Lord Chief Justice Dyer said, that the judge who took the fine was not worthy to take another, but notwithstanding this, and although the monstrous deformity and idiocy of Bushley was apparent and visible, yet the fine stood good. It was moved as a doubt in the Court of Wards, whether this fine should not enter to the use of the idiot and his heirs, for although it was agreed, that the fine, being of record, bound the idiot, yet it was contended, that the deed executed by the idiot, was not sufficient to direct the uses of the fine, but it was resolved, that forasmuch as he was enabled by the fine as to the principle, he should not be disabled to limit the uses which are but as accessory. 1 Hugh Lewing, who was an idiot, and so found by office, levied a fine, and declared the uses of it by indenture. It was resolved in the Court of Wards by the Lords Chief Justices Ray and Dryer, that both the fine and new declaration of uses should stand good, as neither Hun Lewing nor his heirs could aver that he was an idiot, and it was said by the court, that they would sooner suppose the office found to have been erroneous, than bring a judicial act into question, or the judgment of the court in which the fine was levied. A complaint was made to the Court of Common Pleas, by Thomas Cust, supported by many affidavits, setting forth, that Joanna Lister, one of the cognizers, in a fine lately levied, had for some years past been disordered in her senses, and was so at the time when the said fine was levied. The court thereupon made a rule to show cause why the fine should not be vacated, and for John Hancock, one of the commissioners, who, with 2 others took the fine by dedimus potestatum, to answer the matters in the affidavits. Upon an enlargement of the rule, the court recommended it to them to produce the said Joanna Lister, who resided in Yorkshire, and accordingly she was brought into court, and being examined by the Lord Chief Justice, appeared to be a person of good capacity, and very well to understand the intent of a fine, and the deed declaring the uses thereof, which was in favour of her husband, with whom she had lived many years, and upon whom she was desirous to settle her estate, and prevent its descending to the said Thomas Cust, her nephew and heir at law. The court discharged the rule, with costs of the application, and the expenses of the said Joanna's journey to Westminster, to be paid by Cust. Idiots, lunatics, and, generally, all persons of non-sane memory, are disabled from suffering common recoveries, as well as from levying fines, though, if an idiot or lunatic does suffer a common recovery, and appears in person, no averment can afterwards be made that he was an idiot or lunatic, but if he appears by attorney, I presume such an averment would be admitted, upon the same principle that an averment of infancy may be made against a warrant of attorney, acknowledged by an infant for the purpose of suffering a common recovery, as the fact of idiocy may be tried by a jury, with as much propriety as the fact of infancy. Although no averment of idiocy or lunacy can be made against a recovery, where the parties appear in person, yet evidence of weakness of understanding has been admitted, to invalidate a deed to make a tenant to the precipe, for suffering a common recovery, and the recovery has, in that manner, been set aside.